Testing sound. 1, 2, testing sound. Testing sound. 1, 2.
Oh, there we go.
Families of up to 8 connected devices, which means they need even more speed. Spectrum Internet delivers with new start.
Good morning, Peggy.
Morning.
How are you?
Good. How are you?
Good. All right. I'm going to give you a break for a minute before we start everything up.
I just sent the record request list.
Thank you. Miss Peggy, I see your beautiful face. You ready to go, Aunt? Good morning, everyone. To the gentleman, excuse me, joined by Galaxy S8. May I have your name so I can fix it on the computer? Can he hear me? He cannot hear me. Okay.
Ms. Barker, this is Bobby Jones.
How are you?
I'm fine. My client's been out of state. We sent the plea documents to Miss Flournoy this morning, and if she's on here, she needs to know she needs to. Oh, you already got it?
I got him back.
Good. Okay, I didn't know she had signed them. Well, wonderful.
Yep,
Thank
she
you,
just sent
ma'am.
them.
You're always
Yes,
so
sir.
efficient.
I'll
Okay,
try.
thank you.
Okay.
The county jail's on, Your Honor.
Thank you, Deputy. Thank you, Deputy Burke.
Yes, ma'am.
Good morning. We'll begin with the guilty plea docket. Number 1, Tyler Marshall, and also number 2, Tyler Marshall, have been moved to April the 7th. Number 3, Donquarius Fletcher, has been closed. Number 4, Trendavious Thomas, closed. Number 4, David Thomas.
Can't hear it.
Trendavious Thomas has been moved to tomorrow, Friday. So the first case is Demetrius Williams. Ms. Dillon?
Yeah, that's my case, Your Honor. That is not a plea today. I don't know who's handling that for the state.
I will be the one handling it for the state. This is Attorney Vanessa Flournoy.
I'm sorry, I couldn't understand you.
I couldn't understand you either, Ms. Flournoy.
I'm sorry. Can you hear me now? Hello?
That's better.
Okay, this is Attorney Vanessa Flournoy. I will be covering handling this case for the state.
Okay.
All right. Thank you, Ms. Flournoy. But Ms. Dillon, you just said that he will not be a guilty plea today. Is that correct?
That's right, Your Honor. He has a more serious case. I know he has a felony forgery with multiple counts of forgery that he's represented by William Kendrick. When Ms. Schwartz had the case, he was waiting to see what happened with the other case and never made a recommendation on this one, because this is just a misdemeanor obstruction is all that's left.
All right, well then
So-
this is off. This will be off for today.
Um,
Number 6, Emmanuel Walton is off. Mr. Kendrick is in trial with Judge McBride this week. Number 7, Nicholas Weaver has been closed. Number 8, Jamie McCrary has been closed. Number 9, Joshua Shepherd needs to be removed today because he is with the Department of Corrections. He'll have to be rescheduled. Number 10, Natalie Kincaid. Mr. Guzman has a leave
Your
this
Honor,
morning.
if I can interject, I have the paperwork on Natalia Kincaid. I just sent an accusation to Ms. Flournoy. That should be the last piece of paperwork. We should be able to close this one out today with a guilty plea. I can sit in for Mr. Guzman.
All right, then Ms. Kincaid will need to come into the courtroom to be advised of her rights.
And she is appearing by Zoom today, Your Honor. She's here.
Be through with Brown, ready for the next one.
Everybody back here, let me know.
Ms. Kincaid, can you wave or say something so we can identify you?
Yes, I'm right here.
All right, I see you. Just stay with us.
Okay.
Number 11, Raven Fike. All right, Ms. Fike, just stay with us on the Zoom call. All right. Good morning, Counselor. Number 12, Lamarcus Edmonds. That's Mr. Guzman's case. Are you handling that for him this morning, Mr. Ramondo?
Correct, Your Honor. However, that's not going to be a guilty plea today. We can remove that case from today's docket.
All right, number 12 is removed. Number 13, Kadarius Leonard. Are you going to handle that plea in absentia, Mr. Ramondo, or should we wait for Mr. Guzman?
I thought that it was just a matter of filing the plea in absentia paperwork. If I can have the copy of the paperwork, though, we can put it on the record today.
All right, we'll do that.
I would ask that it be moved because we have not created the paperwork yet for the plea in absentia.
Okay.
All right. Do you think it would be ready tomorrow, Ms. Flournoy? We'll be
I
back.
will do my best, Your Honor.
All right. Then we're going to move it to Friday, the 18th, and hope for the best. Number 14, Natasha McQueen is moved until April the 7th. Is that correct, Mr. Ramondo? Or do you know? Well, that's Mr. Lakes.
Yeah, that's Mr. Lakes.
He has a leave. Number 15, Naisha Shorter is also moved to April the 7th because of Mr. Lake's leave. Number 16, Marcus Hawk. Mr. Whitaker, are you with us? Is Alfonso Whitaker? Okay, we'll recall this case after we attempt to locate Mr. Whitaker. Number 17, Matthew Bill. Are you going to handle that? You're going to handle that?
I'm sorry to keep on cutting you off, Your Honor. I'm able to handle that today.
You are or you are not?
Are. Yes, sir.
All right. All right. Then is he on the Zoom call?
Your Honor, on that one I have that he should be at the jail or at Recorder's Court. I apologize.
All right. Deputy at the jail, is Matthew Bill there?
You call Matthew. Yes, I got it, Jan. Hold on. That's Matthew Beal.
I'm on the Zoom call.
Oh, he's on the Zoom call. Okay.
All right. Very good, Mr. Bill. Just stay with us. We'll come back to you. Number 18, John Franklin.
Good morning, Your Honor. Mr. Franklin is seated next to me this morning. We will be entering a plea.
All right. He'll be advised of his rights in just a few minutes. Mr. Jones, thank you.
Your Honor, if I may please the court, there was no response on Matthew Beal.
Thank you, Deputy. It turns out he is on the Zoom call with us.
Thank you, sir.
Number 19, Derek Flakes.
Okay. Okay.
Now, the docket is not annotated, but it does appear that he's represented by William Kendrick, who has a conflict this morning as he is in a jury trial. Is Derek Flakes on the call?
Yes, sir.
All right. What did your attorney tell you to do as far as this morning? Did he tell you to get on the Zoom call, or did he tell you he was already in trial?
Yes, sir. He said he had trial this morning, sir, but he told me I needed to be on call, whatnot.
Okay.
Just to
Well,
be
just
present for the call.
Just stay with us, Mr. Flakes. We'll try to determine if Mr. Kendrick thinks he's going to be able to join us. We'll recall your case. Thank you.
All right.
Mr. Flakes, I do see a note here. Mr. Flakes, are you out there?
Yes, sir.
You can go ahead and sign off. Mr. Kendrick has sent word that he is not going to be able to get away from Judge McBride's court. So this will be rescheduled for you, sir. But you can drop off. Have a good day. It'll be rescheduled.
All right, you too, sir.
Thank you.
All right.
Number 20, Shannon Buckner. That's Mr. Lakes. It's been moved to April the 7th. As has number 21, Shannon Buckner again, moved to April the 7th. Number 22, Ladarius Bennett, also moved to April the 7th. Number 23, Tetris Sweat has been moved. Well, will have to be rescheduled due to Mr. Kendrick being in trial with Judge McBride, so it's off. Number 24, Courtney Beanick.
Your Honor, that one can be removed from today's docket. We don't have a finalized plea in that one. We're getting close, though.
All right, thank you.
Yes, sir.
And Nikki Mims. Mr. Ramondo, are you handling it, or should we wait for Mr. Guzman?
I'm here.
And I'm able to handle that one for Mr. Guzman, Your Honor. My understanding is that the paperwork has been filled out, so we should be good to go.
All right. Did Ms. Mims say something? Are you here?
I think she just said that she was present, Your Honor, via Zoom.
Okay, well, that'll be today. All right. At the jail, is there anyone in custody who needs to be brought to the courtroom to be advised?
We've got the first 5 that's on the list. I think it's only like 7 or 8, Your Honor, but we have the first 5 when you're ready.
Well, now, are they on the guilty plea, or are they bonds and status conferences?
This is going to be right now with the motions and status conferences. Now you just got through with the guilty plea, sir.
Oh, okay. Well, don't bring anyone out. But I believe you had one defendant who was there off the street. Is that correct, officer or deputy?
At this moment, we don't. After we called the first docket, I just only called that one, that bill that you told me to call, and there was no answer.
All right. That's fine. And do we have the paperwork on all of these? Okay, we're going to take about a 5-minute recess to get a list of those who will be entering guilty pleas this morning. We'll return, as I say, in about 5 minutes. Thank you.
5 minutes. We'll be in recess for 5 minutes. Let me check. Leonard.
Deputy Burke, I'm going to mute the jail camera for a moment, okay?
Okay.
Oh,
Thank you.
Hey, Jill, I don't know if you guys can hear me. Just to give you a heads up, we're not going to need Miss Sandra Treadway.
Mr. Johnson, I have that on for a bond motion. Did that get worked out?
I'm gonna withdraw that bond motion. I'm gonna first and foremost, good morning, Liz.
Good morning. How are you?
It's an interesting one. What's today? Thursday.
Yeah, please don't say Monday and rewind the week.
Yeah, it's bring your kids to work day. So what was I gonna say? It didn't get worked out, but we're gonna work something out.
Okay, so remove Sandra Treadway.
Correct, and I'm also gonna ask that her revocation that is set for today be continued to the next available day. Well, not next available day. I think you have the 19th is next available, but whatever is the one after that.
April 7th.
That'll work.
April 7th. All right, I'll write that down. I will let the judge know.
Oh, well, do I need to make that announcement? Or?
Well, you can make the announcement, but I was going to go mark it on his docket.
Okay. All right.
Okay.
My kid said, "Hey, Liz." They'll be remiss if I didn't say anything.
Well, I was hoping I would see his cute face, but. Hey, buddy.
You want to show him he's throwing a tantrum? Because I couldn't let him. Here. Say hello.
Hi. Good morning.
She can hear you. You're not going to say hello? See, he did all that complaining, and now he just like, now that daddy hurt my feelings.
That's too funny. All right. Well, I hope you have a fabulous day. And Judge Smith, I've just printed the list. I'll be out there with it in a moment.
All right, we're back. Miss Little, are you there?
Yes, I'm here, sorry.
Oh, that's all right. All right, I need the following individuals to speak up so that I see your face, and make sure your microphone is on. I'm about to advise you of your constitutional rights. I'll need to be able to see you and also to hear your answers to the questions that I pose to you. Natalie Kincaid.
Yes.
All right.
Right here.
Good morning.
Good morning.
Raven Fike.
Yes, good morning.
All right. Good morning, Ms. Fike. Did Mr. Whitaker get on the Zoom conference, Ms. Barker?
No, sir, not yet. I'm working on still trying to reach him.
All right. Thank you. Matthew Bill. Matthew Bill.
Here. I'm here.
Just wave, Mr. Bill, so it activates.
Video. Hold on.
Do you have your video phone on?
Yeah, I'm.
All right.
Okay.
Thank you. John Franklin.
Here.
Where are you, Mr. Franklin?
He was here on Robert Jones.
All right. Thank you. And Nikki Mims. Miss Mims. Mr. Ramondo, do you know where Miss Mims is?
She was here a moment ago, Your Honor, but I don't see her name anymore. I will try to get in touch with her and see if she can rejoin the chat.
Your Honor.
Yes.
Before we do this mass advisement, I see one problem. When we mass advise on Zoom, when you ask the question and they all answer in unison, there will not be audio, but for whoever comes in the first and the strongest, the other ones, I will not hear their voices at all.
Okay. Well, there are only four. There are only four that are going to be advised this morning. I'll do the advisement, then I'll call on you by name individually so that your answer is recorded and is audible to the court reporter. If the four of you would please raise your right hand and take an oath to tell the truth. Do you solemnly swear or affirm that any testimony you may give in court today will be the truth, the whole truth, and nothing but the truth, so help you God? You put your hand down. Ms. Kincaid, did you raise your hand?
Yes, sir.
Ms. Fike, did you raise your hand?
Yes, sir.
Thank you. Mr. Bill, did you raise your hand?
Yes.
Mr. Franklin, did you raise your hand?
Yes, I did.
All right, thank you. Thank you all. Now, this is a guilty plea docket this morning, and I understand each of you wish to enter a guilty plea to the charges you face. But before I can accept a guilty plea, I'm going to advise you of your constitutional rights and make sure that you understand what you're doing and what your rights are in your case. Is there anyone among the four of you who is not a U.S. citizen? Ms. Kincaid, are you a U.S. citizen?
Yes.
Ms. Fike, are you a U.S. citizen?
Yes.
Mr. Bill, are you a U.S. citizen?
Yes.
Mr. Franklin, are you a U.S. citizen?
Yes, I am.
All right, thank you. Do you each understand that you have the right to plead not guilty and demand a jury trial in which case the state of Georgia must prove each and every element of each crime with which you're charged. Do you understand that, Ms. Kincaid?
Yes.
Ms. Fike?
Yes.
Mr. Bill?
Yes.
Mr. Franklin? All right, thank you. Do you understand that if you plead not guilty, the Constitution guarantees you at trial certain rights, including the following: the right to a public and speedy trial by jury. You begin with the benefit of a presumption of innocence. You have the right to confront and to question witnesses. You have the right to subpoena witnesses and evidence in your favor. And you have the right to the assistance of an attorney during such a trial. And if you could not afford an attorney, one would be provided to you by the state of Georgia at no cost to you. Do you understand these rights so far, Ms. Kincaid?
Yes.
Ms. Fike?
Yes.
Mr. Bill?
Yes.
And Mr. Franklin?
Yes, I do.
Thank you. Do you all understand that you have the right to testify and to offer other evidence during such a trial, but you also have the right not to incriminate yourself? Stated in a slightly different way, you have the right, if you wish to testify, no one can stop you from testifying. On the other hand, if you do not wish to testify, no one can force you to testify, nor can anyone comment on that decision in front of a jury or hold it against you in any way. Do you understand that, Ms. Kincaid?
Yes.
Do you understand that, Ms. Fike?
Yes.
Mr. Bill?
Yes.
And Mr. Franklin?
Yes.
Do you understand that if you plead not guilty or simply remain silent, the court would enter a not guilty plea for you and you would secure a jury trial with all of these rights? Do you understand that, Ms. Kincaid?
Yes, sir.
Thank you. Ms. Fike?
Yes, sir.
Mr. Bill?
Yes.
And Mr. Franklin?
Yes, sir.
Thank you. Do you understand that if you plead guilty, as I understand you wish to do, you will be giving up those rights? Ms. Kincaid, do you understand?
Yes, sir.
Ms. Fike?
Yes, sir.
Mr. Bill?
Sir.
And Mr. Franklin?
Yes, sir.
Thank you. Now, in some of your cases, you may have as a special condition of your sentence or your probation, a requirement that you waive your rights under the Fourth Amendment to the U.S. Constitution. And that's a valuable right that we enjoy, and I want to make sure you understand what you may be called upon to give up. A Fourth Amendment waiver means the following: that you would submit to a search of your person or property at any time of the day or night, with or without your consent, and without a search warrant, whenever called upon to do so by a law enforcement or a probation officer. It further means that anything that might be found or taken as a result of such a search could be used against you in any court proceedings. Do you understand that, Ms. Kincaid?
Yes, sir.
Ms. Fike?
Yes, sir.
Mr. Bill?
Yes, sir.
And finally, Mr. Franklin?
Yes, sir.
All right, thank you. Now, if you enter a guilty plea today, you will have a conviction either for a misdemeanor or a felony. And you have certain rights that I want to describe to you now. If you believe there have been any irregularities in these proceedings, you can file what is known as a writ of habeas corpus, but there are time limits for doing that. In the case of a felony, you must file your habeas corpus motion within 4 years of the date that your sentence in this court becomes final. In the case of a felony, you have only 1 year to file that petition. And in the case of a traffic misdemeanor, you have even less time. You only have 180 days to file that petition. Does everyone understand?
Yes.
Okay.
Yes.
All right. Mr. Bill?
Yes. Yes.
And Mr. Franklin, do you understand? Thank you.
Yes, sir.
All right. Now, if your sentence requires that you be incarcerated, I would advise you of the following consequences of escape. If you have been convicted and sentenced to confinement and you intentionally escape from lawful custody or any place of lawful confinement, you could be charged with the felony offense of escape, which upon conviction is punishable by a period of up to 10 years in the state penitentiary. If, however, you escape while armed with a dangerous weapon upon conviction, you could be sentenced to a period of up to 20 years in the state penitentiary. Does everyone understand?
Yes.
Ms. Kincaid, Ms. Fight,
Yes.
Mr. Bill,
Yes.
and Mr. Franklin.
Yes, sir.
Thank you. One last advisement. Although you may have signed a document saying that you do not have the right to appeal your guilty plea, in fact, you do have such a right. But if you wish to file an appeal of your guilty plea, you must do so by filing a notice of appeal in writing and file it with the clerk of the Superior Court of Muscogee County, Georgia, within 30 days of today's date. Do you understand, Ms. Kincaid,
Yes, sir.
Ms. Fike,
Yes, sir.
Mr. Bill,
Yes, sir.
and Mr. Franklin?
Yes, sir.
All right. All right. Thank you. Everyone stay on the Zoom call. I'm going to take one case at a time. We'll begin with Mr. Franklin.
Your Honor, if I could make an announcement, Your Honor.
Certainly, Mr. Johnson.
Judge, I just wanted to make an announcement as it pertains to position 3 on the revocation docket and position 3 on the motions and status. I would like to withdraw my motion for bond, Judge, and I would like to have Ms. Treadway on the next available docket. I believe that's the 12th, Judge, and I wanted to let the jail know that she did not need to be brought down.
All right. Any objection from the state on the VOP?
No objection from the state, Your Honor. We will.
All right.
Get a continuance for this time.
All right. Thank you. So Sandra Treadway, who appears on the guilty plea on the bond docket and also on the violation of probation docket, does not need to be brought downstairs, and she will be moved to the next docket. Ms. Leonard, can you do that for us?
Yes, sir. And Mr. Johnson, that date's going to be April the 7th.
April the 7th. Thank you. And
You're welcome.
Your Honor, that's all I have for this morning. May I be excused?
Yes, sir. Have a good day, Mr. Johnson.
See you tomorrow, Judge.
Thank you. All right, Mr. Franklin, you were on the Zoom call, have been all morning, I suspect, but you were present when I was advising all defendants of their constitutional rights. Is that correct, sir?
Yes, sir.
Were you able to hear and understand what was being said?
Yes, sir.
Right. And you also raised your right hand and took an oath to tell the truth, correct?
Yes, I did.
All right. You're still under oath, and I'll have a few questions for you as we go through your guilty plea. And I'd like to count on you to answer my questions truthfully. May I do that, sir?
Yes. Yes, sir.
All right.
Yes, sir.
All right. Ms. Franklin, Ms. Flournoy, if you would please state the factual basis for the charges against Mr. Franklin and the negotiated recommendation.
Your Honor, we can stipulate that there is a factual basis in that the officer stopped him for a traffic violation and he consented and he found the objects that he's charged with.
All right. Is the state satisfied with the stipulation?
Your Honor, the state is satisfied with the stipulation with the accurate depiction of what happened. Summary of what happened.
Ms. Flournoy, I'm having a terrible time understanding you. Is there any interference there at your end?
Not
getting
that I
by?
know of, Judge.
There, I can hear you now.
Okay,
So
I
what-
increased my volume. Okay. I
All
didn't
right,
realize it was down. Is that better?
That's much better, Ms. Flournoy.
Thank you,
Did
Your Honor.
my question to you was this: is the state satisfied with the stipulation to a factual basis?
Yes, Your Honor, we are.
All right, thank you. All right, well, this is the recommendation. Mr. Franklin, count one, possession of controlled substance, which is a felony. The recommendation is 3 years probation. Count two, possession of drug-related objects, which is a misdemeanor, 12 months probation concurrent with count one. And count three, failure to maintain brake lights in good working condition, 12 months probation concurrent to count one. That is the sentence recommendation. Ms. Franklin, there's a long list of special conditions. Mr. Franklin, listen carefully as Ms. Flournoy reads those special conditions of probation.
It is a $500 fine assessed on count number one. He's eligible for first offender status. He's not eligible for a conditional discharge due to a previous conviction. And if he elects the first offender and is granted it, under OCGA 1710-1A1B, behavior incentive date, 2 years from the date of sentence. Within 2 weeks of the date of sentence, defendant shall undergo evaluation for alcohol, drug abuse at a facility approved by the Community Supervision Office and shall complete any recommended treatment. Probation Management Act sentencing options system with sanction cap of PDC or RSAT. 80 hours of community service. Report to Community Supervision Officer as directed. Fourth Amendment waiver. Alcohol drug testing. Waiver of evidentiary foundation for admission of results of alcohol drug testing in any court proceeding. Records release. Abide by any curfew if directed by the Community Supervision Officer. Provide DNA sample if adjudicated guilty of a felony during the pendency of sentence. Provide proof of completion of high school diploma, GED, or training certificate. Do not consume alcohol beverages or any controlled substance or dangerous drugs unless prescribed. Do not associate with anyone who uses or possesses any controlled substance or dangerous drugs unless prescribed. Do not occupy any residence or vehicle where alcohol or unprescribed controlled substance or dangerous drugs are present. Undergo evaluation for contagious communicable disease if directed by community supervision. Do not possess any firearms or ammunition or any weapon as that term is defined by OCGA 1611-125.1.
All right, did you hear and understand the sentence recommendation from the court and also the special conditions as read by the district attorney?
Yes, I did hear, Your Honor.
All right, is that what you agreed to?
Judge, may I?
Yes.
It may help, Judge. Your Honor, I had already let Ms. Flournoy know by email earlier today that I would address the court on two subjects. Number one, he's 63 years old. He's been employed by the same HVAC employer for the last 13 years, and he travels all over the state of Alabama. And being that he's been, and he's worked in HVAC more than 13 years, but the same employer for the last 13, and I would ask that the GED not be made a requirement. And further, when I had discussed this case with Ms. Schwartz, and Ms. Flournoy is correct, he isn't ineligible for conditional discharge, but the part in there about an evaluation and possible treatment was only if we were going to do conditional discharge. And in as much as he's presently, his company is working over in Montgomery, and we expect a job to begin before long in Mobile, and he has to travel a lot, and his probation is going to have to be transferred anyway. I would ask that the evaluation and/or treatment and the GED, unless respectfully to Ms. Flournoy, unless she has a valid objection, that those not be made a part of the sentence.
What does the state say, Ms. Flournoy?
Your Honor, based on the charges, we felt that it was a key term to the sentence, but we will defer to the court. Whatever the
All
court
right.
decides, we will go along
Thank
with
you,
it.
ma'am.
All right, so Mr. Jones, you were asking to strike alcohol and drug testing.
No, Your Honor. No.
Okay.
We're asking to strike the requirement that he obtain a GED or high school diploma. And also that the part where it says evaluated and if necessary treatment for the next 90 days, I believe is what it says, that be stricken. And we're in agreement with everything else.
All right, then I'll grant your request on that. All right. Mr. Franklin, have you been asked to read or sign anything in court today that you do not understand?
These documents. Have you been asked to sign anything that you didn't understand?
No, I haven't.
All right. Have you ever been treated for a mental illness, sir?
No, sir.
This morning, are you under the influence of alcohol, drugs, narcotics, or any medications?
No, I'm not.
All right. Are you clear-headed about what you're doing in court today?
Yes, I am.
Other than the sentence recommendation, has anyone offered, promised, or given you anything to convince you to enter a guilty plea to these charges?
No, sir.
All right. Has anyone used any force against you to secure your guilty plea?
No, sir.
Now, Ms. Flournoy indicated that you're eligible to be sentenced as a first offender. Mr. Jones, does Mr. Franklin wish to avail himself of that type sentence?
He does, Your Honor, and I have explained the ramifications. Plus, he has initialed and signed the first offender document supplied by Assistant DA, Ms. Flournoy.
All right, very well then. Did you understand everything that you initialed to Mr. Franklin?
Yes, I did.
All right, then I will sentence you as a first offender. Okay. Now, did you hear and understand the advisement regarding the meaning of a Fourth Amendment waiver?
Yes, I did.
Okay, that's going to apply to you. Do you understand that?
Yes, sir.
Okay. Mr. Franklin, do you freely and voluntarily admit your guilt to the charges you face?
Yes, sir.
Do you admit that there is a factual basis to support your guilty plea?
Yes, sir.
And do you now wish to enter your guilty plea?
Yes, I did. Yes, sir.
All right. Mr. Franklin, you're represented by Mr. Bobby Jones, who sits there with you this morning. Have you had enough time to discuss your case with Mr. Jones?
Yes. Yes, sir.
Are you set? I'm sorry, I spoke over you. Have you had enough time?
Have you had enough time to tell me everything you need to tell me?
Yes, sir.
Okay.
Yes,
Are you satisfied with the representation you've received from Mr. Jones?
Yes, sir.
Is there anything you would like to say? You're not required to, but this is your opportunity.
No, sir.
Okay. Mr. Jones, is a sentence recommendation that I read earlier and the conditions which Ms. Flournoy read, are those the same sentence? Is that the same that you negotiated for Mr. Franklin?
Well, yes, except for the GED and the.
Yes.
Yes, sir. Yes, it is.
All right. Then that's fine. Do you believe that your client understands his constitutional rights?
He does, Your Honor, and I apologize to the court. I'm getting a little senior myself and not hearing so well, and I may have misheard you. I did hear you say, does he understand that he has a right to a trial and that the state must prove him guilty? I did not hear beyond a reasonable doubt. And then when you were explaining habeases, I heard you say 2 years for a felony, and then you said 1 year for a felony, not a misdemeanor, I thought. I could have misheard you. But in any event, I have carefully explained all these rights to him. He does understand them, and he read and acknowledged on the plea form that he understands that he's got to be proven guilty of each and every element of the crime beyond a reasonable doubt. And he understands his habeas rights.
All right. If I misspoke, I apologize, but Mr. Jones has correctly stated it on the habeas corpus. It is 4 years on a felony, 1 year on a misdemeanor, and only 180 days on a traffic misdemeanor. And Mr. Jones is absolutely correct. If you go to trial, the state has to prove you're guilty of each element of each offense with which you're charged beyond a reasonable doubt, which is the standard in criminal cases. All right. Mr. Franklin, the court finds that you understand the nature of the crimes and the consequences of a guilty plea. The court finds that you understand your constitutional rights and that you have and you are making a knowing, intelligent, free, and voluntary decision to enter your guilty plea. And the court further finds that there is a factual basis for your guilty plea as evidenced by your stipulation to a factual basis. And I will accept your guilty plea and sentence you in accordance with the recommendation. If you and Mr. Jones will sign the charging instrument if you've not already done so.
They have been signed and returned to the court.
All right. Thank you, Mr. Jones. That being the case, I do accept your guilty plea, Mr. Franklin, and I sentence you as follows. Count 1, possession of a controlled substance, 3 years probation. Count 2, possession of drug-related objects, a misdemeanor, 12 months probation concurrent to count 1. And count 3, failure to maintain brake lights in good working condition, also a misdemeanor, 12 months probation concurrent with count 1. This sentence is under the provisions of the Georgia First Offender Act. You've acknowledged that you heard and understood the special conditions, and I will not repeat those, but at your attorney's request, you are not required to undergo an evaluation for alcohol, drug abuse. You're also not required to provide proof of completion of a high school diploma, GED, or a training certificate. If you've been working in the heating and air conditioning industry, you've got a good trade, which is part of the objective for that requirement. Otherwise, other than that, all the other special conditions as read by Ms. Flournoy are part of your sentence. Do you have any questions about your sentence?
No, sir.
All right. Well, thank you. Good luck to you, Mr. Franklin. When would the community supervision officer want Mr. Franklin to report?
Yes, Judge, this is Officer Davis. He can report today and fill out an information sheet at 1334 2nd Avenue.
All right.
Will he receive a travel pass since he has been a resident of Alabama for over 13 years and all throughout this offense? And
okay, so if he's gonna be living in Alabama, he needs to come to the office with a $100 money order so that we can start the transfer fee. His case will have to be transferred to Alabama, but he'll need to come to the office today to do that, and it's a $100 fee.
I'll send him immediately, but he will not have the 100 until tomorrow.
Okay, we'll just discuss it with him when he gets here, but he'll just need to report to the office.
Thank you, Ms. Davis. I'll direct him to where it is. May I be excused, Your Honor?
Yes, sir. Have a good day, Mr. Jones.
Thank you. Same to you, sir.
Thank you. All right. Ms. Kincaid, are you there? Ms. Kincaid?
Yes, I'm here.
All right. Mr. Raimondo, are you ready to proceed?
Yes, sir.
All right. Ms. Kincaid, you were present earlier this morning to receive your rights. Is that correct?
Yes, sir.
Were you able to hear and understand what was being said?
Yes, sir.
Okay. All right. You also raised your right hand and took an oath to tell the truth. Do you remember that?
Yes, sir.
And you're still under oath. I'll have some questions for you as we go through your guilty plea, and I'd like to be able to count on you to answer my questions truthfully. May I do that, ma'am?
Yes, sir.
All right, thank you. Ms. Flournoy, if you would, for the record, state the factual basis for the charges against Ms. Kincaid and your recommendation.
Yes, sir, Your Honor. This is a traffic stop that, this case involves a traffic stop that happened on November the 1st of 2019. She was stopped for speeding. After she was stopped, it was discovered that she didn't have any license. Therefore, she was driving on suspended license. She was arrested. As a part of the inventory of the car, it was discovered some tablets that were later identified as methamphetamine. That's the basic summary of the case. It is our recommendation on this case, State of Georgia versus Natalia Kincaid, 19 CR 4513. It is one count of possession of a controlled substance, 3 years probation, driving without a license, 1 to 12 months. It is a 12 months. Our recommendation is 12 months probation concurrent to count 1. Count 3 was the speeding, and we would not cross that as a part of this plea agreement. Special conditions is 100 hours of community service, and that is in lieu of any fine. We did an increased amount of community service. First offender, she is eligible for first offender status, a Fourth Amendment waiver, and if first offender is requested and granted, a behavior sentence 2 years from the date of the sentence. That is our recommendation.
All right, thank you, Ms. Flournoy. Ms. Kincaid, did you hear and understand the sentence recommendation?
Yes, sir.
Are you in agreement with that recommendation?
Yes, sir.
Other than the recommendation, has anyone offered, promised, or given you anything in exchange for your guilty plea?
No, sir.
Has anyone used any force or threat of force to obtain your guilty plea?
No, sir.
Have you been asked to read or sign anything in court today that you do not understand?
No, sir.
Have you ever been treated for a mental illness?
No, sir.
This morning, are you under the influence of alcohol, drugs, narcotics, or any medication?
No, sir.
All right, thank you. Now, the district attorney has indicated that you're eligible to be sentenced as a first offender. Do you wish to be sentenced as a first offender?
Yes, sir.
Okay. Mr. Raimondo, have you gone over the provisions of the Georgia First Offender Act, the advantages and the risk associated with such a sentence?
Personally, no, Your Honor, but Mr. Guzman has, to my understanding. Ms. Kincaid, do you recall Mr. Guzman going over the benefits?
Yes.
And potential consequences of the First Offender Act?
Yes, sir. Yeah, I have.
All right. Did you understand what Mr. Guzman was telling you?
Yes, sir.
And would you like to be sentenced as a first offender?
Yes, sir.
All right, then I intend to do that, Ms. Kincaid.
Okay, thank you.
You're welcome. All right. Did you hear and understand the meaning of a Fourth Amendment waiver?
Yes, sir.
Are you in agreement with that?
Yes, sir.
That will apply in your case.
Okay.
Ms. Kincaid, do you freely and voluntarily admit your guilt to the charges against you?
Yes, sir.
Do you admit that there is a factual basis for the charges against you and your guilty plea to those charges?
Yes, sir.
Do you now wish to enter your guilty plea?
Yes, sir.
All right. Now, Ms. Kincaid, you're represented, you have been represented by Mr. Jose Guzman, and this morning, Mr. Alessandro Ramondo is standing in for Mr. Guzman. First of all, did you have enough time to discuss your case with Mr. Guzman?
Yes, sir.
Are you satisfied with the representation you received from Mr. Guzman?
Yes, sir.
Are you agreeable? Are you comfortable with Mr. Ramondo standing in for Mr. Guzman this morning?
Yes, sir.
All right. Is there anything you'd like to say? You're not required to, but this is your opportunity if you wish.
No, sir.
Mr. Ramondo, is the sentence recommendation that we heard from Ms. Flournoy the same sentence that was negotiated for Ms. Kincaid by Mr. Guzman, to your best knowledge?
Yes, sir, it was.
All right. Do you believe Ms. Kincaid understands her constitutional rights?
Yes, sir.
And do you believe that she has and she is making a knowing, intelligent, free, and voluntary decision to enter this guilty plea?
Yes, sir.
All right. Other than to ask the court to follow the recommendation, is there anything further you'd like to say on behalf of Ms. Kincaid?
No, sir.
Thank you. All right. Ms. Natalie Kincaid, the court finds that you understand the consequences of a guilty plea, that you understand your constitutional rights.
Yes, sir.
That you have made a knowing, intelligent, free, and voluntary decision to enter this guilty plea. And I will accept your guilty plea and sentence you in accordance with the recommendation. If you and your attorney will now sign the charging instrument, if you've not already done so.
And that paperwork should be with you, Your Honor.
All right, thank you. It is. All right, Ms. Kincaid, I accept your guilty plea and I sentence you as follows. And this sentence is under the provisions of the Georgia First Offender Act. And I am setting a behavioral incentive date for March the 18th in the year 2023. This is the sentence and the conditions, special conditions of probation. Count 1, possession of controlled substances, 3 years probation. Count 2, driving without a license, 12 months probation concurrent with count 1. And having successfully entered your guilty plea to counts 1 and 2, and on the state's motion, count 3, speeding, is null prost. Special conditions of probation are as follows. You'll perform 100 hours of community service. As I already said, you're sentenced under the Georgia First Offender Act, and a behavioral incentive date is set for March 18th, 2023. That is your sentence and conditions. Do you have any questions, Ms. Kincaid?
No, sir.
Did you hear and understand the advisement regarding your habeas corpus rights?
Yes, sir.
All right. On the possibility that Mr. Jones was correct and I misstated those rights, let me tell you what they are again. You've been convicted of a felony and traffic misdemeanor. In the case of the felony, you have a period of 4 years from today's date to file a habeas corpus petition if you believe that's appropriate. In the case of the traffic misdemeanor, you only have 180 days to file such a petition. Do you understand that?
Yes, sir.
All right. Thank you. Community Supervision Officer, when would you like for Ms. Kincaid to report?
Yes, sir. She can report within 24 hours to 1334 2nd Avenue.
All right. Did you hear that, Ms. Kincaid?
Yes, sir. I am currently in Michigan right now.
Oh. All right.
Do you live in Michigan?
Yes, ma'am.
Okay. You're gonna have to return here in order for us to transfer your case. Now that you're on probation, you're in violation. You would be in violation if you lived out of state right now.
If we make the probation unsupervised, would that assist with that situation?
Well, we'd have to go over the intake and get her to sign the documents and all of that. But I'll give you a call. If you could
Okay.
just send your number through chat.
I'll be fine talking with you, but also I'll send you Mr. Guzman's phone number as well, but we can talk for now and then we'll follow up with Mr. Guzman.
Okay, Ms.
Okay.
Kincaid, Ms. Kincaid, are you still on the call?
Yes, yes, sir.
All right. Report to the community supervision officer at the address that Mr. Ramondo or Mr. Guzman can give you.
Okay.
Within 2 weeks of
Okay.
today's date, unless Mr. Guzman or Mr. Ramondo tell you that they have worked something out with the community supervision officer that relieves you of the reporting. I don't know that that can be accomplished. So if not, within 2 weeks of today's date, report to the community supervision office here in Columbus for intake.
Okay.
All right.
Okay.
Thank you.
Yes,
Thank you.
sir.
Good luck to you, Ms. Kincaid.
Thank you. Have a good
You're
day.
welcome. Thank you. You too.
Can I leave?
Yes, you can come off.
Okay. Thank you. Okay.
All right. Raven Fike.
For me again, Your Honor.
Ms. Fike, are you with us?
Yes, I am.
Oh, all right. I see you. And Mr. Abt,
Good morning.
I see you.
See you.
Good morning. Good morning. Ms. Fike, you were on this Zoom communication platform earlier this morning when I advised everyone of their constitutional rights. Is that true?
Yes,
Were you able to hear and understand what was being said?
yes,
Did you also raise your right hand and take an oath to tell the truth?
yes.
You're still under oath, and I'll have some questions for you as we go through your guilty plea. And I'd like to be able to count on you to answer my questions truthfully. May I do that, Ms. Fike?
Yes, sir. Yes, sir.
Thank you. All right. Ms. Flournoy, if you would state the factual basis for the charges against Ms. Fike and your recommendation.
Yes, sir, Your Honor. Between July 10th, 2015 and March 29th, 2016, the defendant, who was then an employee of Valleywood Incorporated, cashed over 17 checks without the authority of any representative of Valleywood. They were pre-signed checks that were kept in the office to quickly pay for large orders of lumber. The defendant was captured on surveillance cashing the checks. The total amount of the theft at the beginning was thought to be in excess of $120,000. Your Honor, it is our sentence recommendation in case number 19, SU 19 CR 4529. Defendant is Raven Fike. It is a indictment, 18 charges, 18 count indictment. It is our recommendation for a plea of guilty on count number 1, theft by taking, a felony, 10 years probation. Count 2, forgery in the 3rd degree, a felony, 5 years probation, consecutive to count 1. Count 3, forgery in the 3rd degree, a felony, 5 years probation, consecutive to count 2. So a total of 20 years probation. As a part of this negotiated plea, we will be no crossing the remaining counts 4 through 18. Our special conditions are that the defendant shall pay restitution in an amount of $119,860.26 to Valleywood Incorporated, a rate of not less than $500 a month. Your Honor, and it is my understanding that the Valleywood has been reimbursed by the insurance company for everything except $12,000. So a portion of this restitution will be going back to the insurance company.
All right.
The Fourth Amendment waiver, and she is also eligible for first offender.
Okay.
And we did not put a fine on a given amount of the restitution involved in this case, Your Honor.
All right. All right. Did you hear and understand the sentence recommendation, Ms. Fike?
Yes.
Are you in agreement with? Are you in agreement with that recommendation?
Yes.
Other than the recommendation, has anyone offered, promised, or given you anything in order to convince you to enter a guilty plea?
No, sir.
Has anyone used any force or any threat of force against you to secure your guilty plea?
No, sir.
Have you been asked to read or sign anything in connection with your case that you do not understand?
No, sir.
All right. Have you ever been treated for a mental illness?
No, sir.
This morning, are you under the influence of alcohol, drugs, narcotics, or any medication?
No, sir.
Are you clear-headed about what you're doing, Ms. Fike?
Yes.
Okay. All right. The district attorney has indicated that you're eligible to be sentenced as a first offender. Would you like to be so sentenced?
Yes, please.
All right. Mr. App, have you gone over the advantages and the risk associated with the first offender sentence?
I have. Thank you, Your Honor.
Do you believe that your client understands both the benefits and the risk of such a sentence?
He does.
Thank you. And she has signed, she has also signed a document entitled Georgia First Offender Act Benefits and Consequences. So I will sentence you as a first offender, Ms. Pike.
Thank you.
I'm not going to set, nor has the state asked me to set a behavioral incentive date in this case. Given the large restitution amount that you must pay, you may need most of this 20 years to do that. I will say that once you have paid off the restitution, the balance of your probation you won't be off of probation, but the rest of your probation can be on a non-reporting basis. So if you're able to pay off the restitution on an accelerated basis, that will just cause your probation to be unsupervised. Does the state object to that, Ms. Flournoy?
Your Honor, we have no objection to that.
Thank you, Ms. Flournoy. All right. All right. Ms. Fike, do you freely and voluntarily admit your guilt to these charges?
Yes.
Do you admit the facts as alleged by the district attorney?
Yes.
Do you now wish to enter your plea of guilty?
Yes, sir.
Ms. Fike, you're represented by your counsel, Mr. J. Apt. Have you had enough time to discuss your case with your attorney?
Yes, sir.
Do you believe that your attorney has appropriately investigated the charges against you?
Yes, sir.
Do you believe that he spent enough time working on your case?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Is there anything you'd like to say? You're not required to, but this is your opportunity if you wish.
No, sir.
All right. Counselor, do you have any, have you had enough time to prepare for this hearing today?
I have, Your Honor.
In the time that you've spent in preparation with Ms. Fike, do you believe that she understands her constitutional rights?
He does.
Do you believe that she has and she is making a knowing, intelligent, free, and voluntary decision to enter this guilty plea?
He is, Your Honor.
Other than to ask the court to follow the recommendation which you negotiated on her behalf, is there anything further you'd like to say for Ms. Fike?
Just that we stipulate to the restitution amount, and we're asking the court to follow the recommendation.
All right. Thank you, sir. All right. The court finds that you, Raven Rogers Fike, understand the nature of the crime and the consequences of a guilty plea. The court finds that there's a strong factual basis to support your guilty plea. The court finds that you understand your constitutional rights, and the court makes a further finding that you have and you are making a knowing, intelligent, free, and voluntary decision to enter your guilty plea this morning, which I will accept, and I will sentence you in accordance with the recommendation. I would ordinarily ask if the documents have been signed, but the documents are in front of me. I see that you have signed the advice of rights for your guilty plea. Also a Fourth Amendment waiver. And the first offender, let's see, I seem to be missing the signature on the charging instrument.
I'm sorry, Your Honor, what document are you missing?
The accusation or the indictment, the signature joining the issues.
Pretty certain we sent that over, but let me check with my staff.
All right, just
I will have that sent over today.
all right. I'm going to accept your guilty plea based on the representation that the charging instrument with signatures will be sent to the court today. If not, then all of this is void.
Sir.
But I'm sorry, Counselor. Okay. All right. I accept your guilty plea and I sentence you as follows. Ms. Fike, count 1, theft by taking a felony, 10 years probation. Count 2, forgery in the 3rd degree, 5 years probation consecutive to count 1. And count 3, forgery in the 3rd degree consecutive to count 2 for a total of 20 years of probation. Special conditions of probation are as follows: that you'll make restitution payments to your victim in the amount of $119,860.26 to Valley Wood Incorporated or its insurer at a rate of no less than $500 per month. Your rights under the Fourth Amendment to the U.S. Constitution are waived while you're on probation. This sentence is imposed under the provisions of the Georgia First Offender Act. And there are, so we've covered the sentence and the special conditions. Now, having successfully entered your guilty plea to counts 1, 2, and 3, and on the state's motion, counts 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, all of which are forgery in the 3rd degree counts, are null pros. When would the community supervision officer like for Ms. Fike to report?
Yes, so she can report within 24 hours to 1334 2nd Avenue.
Gotcha.
Thank you. Did you hear and understand that, Ms. Fike?
Okay, I did, but if I was going to let Jay speak, I'm sorry.
Your Honor, she is in a hospital, is currently hospitalized in Kentucky. So I am asking the court that delay her reporting until she's discharged from her hospital bed in the state of Kentucky.
Right.
If she can report by phone today, certainly, but as far as physically appearing, I would just ask the court to delay that until she's physically able to travel to Georgia.
Officer Davis, what
Yes,
do you
sir.
say? What do you say?
Is she going to be living in Georgia?
No, she's not, but she can come to Georgia to report and then obviously apply to have the probation to interstate. But I believe she's going to be in patient
Okay.
at least another few days or a week.
Okay, so she'll need to report here when she's released with a $100 money order. She'll need to get the incident report for the case that she's been put on probation on so that we can do a transfer. If you could email me her information, I'll send you my email through chat.
Okay, very good.
All right. Did you understand all of that, Ms. Fight?
Okay, I did. I just wanted to say that I have been released, but I can't travel for at least 2 weeks due to major surgery. So if they could just work that out to give me time to be released to actually travel.
All right. Well, report in person to the Department of Community Supervision with the $100 more money order that the probation officer mentioned within 30 days of today's date.
Okay, that's definitely possible.
All right. Thank you.
Your Honor, I do have a copy of the bill of indictment, but we don't have one that was signed by the state. So what I'm going to do is I'm going to sign it. I'm going to get Ms. Fike to sign it, and I'm going to send it to Your Honor, and I'll copy Ms. Flournoy on our copy of that document, if that's acceptable to the court.
That's acceptable to the court. Is that agreeable, Ms. Flournoy?
Yes, Your Honor, that is. And
All
I'll
right.
sign it and get it to court.
All right. Ms. Fike, did you hear and understand your habeas corpus rights?
Yes, sir.
Do you have any questions about your sentence or anything that occurred on this court session?
No, sir.
All right. Good luck to you.
Thank you.
Ms. Fike. And all right, now we will go to Matthew Bill.
Okay, may I be excused?
Yes, ma'am.
Okay, thank you.
Good morning again, Mr. Bill.
Morning.
You were present on this Zoom call earlier this morning when I advised you of your constitutional rights. Is that correct?
Yes, sir.
Were you able to hear and understand what was being said?
Yes, sir.
And did you also raise your right hand and take an oath to tell the truth?
I did.
All right. You're still under oath, and I'll have some questions for you as we go through your guilty plea. And I'm going to count on you to answer my questions truthfully. Can I do that, sir?
Yes, sir.
All right. Mr. Abt, do you have further business with the court today?
No, Your Honor. May I be excused?
Yes, sir. Have a good day. Thank you.
You too. Stay well.
Thank you. I'm going to try. You too. All right. Ms. Flournoy, if you would state the factual basis for the charges against Mr. Bill and your recommendation.
Yes, Your Honor. And this is State of Georgia versus Matthew Bill, case number SU 20CR 0260. He's charged 3 counts. Count 1 is possession of a controlled substance. Count 2 is driving under the influence, less safe. And count 3 is improper parking. As part of this, I will be reading the indictment to fully establish the basis of each charge, the factual basis of each charge. But this is a case where the police officer was dispatched to an area of Roman Road and Britt David Road on June the 6th of 2019. And they spoke with a witness who said that the driver, who later was identified as the defendant, stated that he had done some heroin about 20 to 30 minutes prior to his arrival. He was given a field sobriety test, and he was not able to pass that. And as a part of the search incident to a lawful arrest, they found a small bag of brown powder, suspected heroin. And the indictment basically count one is unlawful possession of a controlled substance that he unlawfully possessed and have in his control less than 1 gram aggregate weight of, including a mixture of a solid substance containing heroin, a controlled substance under Schedule 1. On count 2, for his driving under the influence of drugs, less safe, it is alleged that on the 6th of June, 2019, in the state of Georgia, county of Muskogee, that he did in there drive and was in actual possession control of a certain 1994 Toyota T100, a moving vehicle, while under the influence of a drug, to wit morphine, to the extent that it was less safe for him to drive, contrary to the laws of the state and good order, peace, and dignity thereof. And then the improper count 3, which is the improper parking. It alleges that on the 6th day of June 2019 in the state of Georgia, county of Muskogee, that he did then and there, being the driver of a vehicle on Grumman Avenue, Columbus, Muskogee County, Georgia, stop and park within 30 feet upon the approach to a stop sign located at the side of the road, contrary to the laws of the state of Georgia, the good order, peace, and dignity thereof. Your Honor, based on those facts, we are making a recommendation in this case on count 1, possession of a controlled substance, 3 years probation. Count 2, driving under the influence, less safe, 12 months probation, served 10 days in jail, and he would receive credit for any time served, concurrent with count 1. And count 3, improper parking, 12 months probation, concurrent with count 1. So that will be a total of 3 years probation. The special conditions are a $750 fine on count 2. He's not eligible for first offender or conditional discharge. Completion of a DUI, alcohol or drug use risk reduction program within 120 days as required by OCGA section 4-6-391. Probation management system options system with sanction cap of PDC and RSAT, 80 hours of community service, and a 4th Amendment waiver.
Thank you. Mr. Bill, did you hear and understand the recommendation from the district attorney?
Yes.
Are you in agreement with that recommendation?
Yes, sir. I was told I'd get credit for time served. I was incarcerated in Muscogee County. Are they going to give me the credit?
Yeah,
I
and
have never heard.
Just for the record, Ms. Flournoy, it's my understanding that Mr. Bell has served those 10 days as required, so there would be no more prison or jail time required on this sentence. He would just be on the probation.
Okay, and I did in my recommendation, it's not on the paperwork, but then I did announce to the court that he would receive credit for any time served.
Okay.
Right. Well, Mr. Bill, you're absolutely right to ask that question, but you do receive credit for time served if you've served enough time that actually 10 days or enough time with credit as may be given by the sheriff, then you do not need to be reconfined. All right. Other than that.
Also, I'm sorry. I
Yes,
took
sir,
the
go ahead.
DUI class. I'm sorry. I took the DUI class last year thinking that court, because I started in March. I started going to court in March for this. And I took it last year thinking that didn't realize it was going to take as long to, you know what I mean? The pandemic.
That is.
Well, could it?
All
right.
I think that's something for Mr. Guzman and you in probation to talk about once you're on probation. Does that make sense?
Yeah.
Okay, Mr. Bill, a lot of things have happened since this time last year. But if you've taken the course, provide proof to the Department of Community Supervision. If it meets their requirements, then you've completed that. But that's going to be between you and the Department of Community Supervision. Now, are you in agreement with the sentence recommendation?
Yes, sir.
Other than the recommendation, has anyone offered, promised, or given you anything in order to convince you to enter a guilty plea?
No, sir.
Has anyone used any force or any threat of force against you for that purpose?
No, sir.
Have you been asked to read or sign anything regarding your case that you do not understand?
No, sir.
Have you ever been treated for a mental illness?
No, sir.
This morning, are you under the influence of alcohol, drugs, narcotics, or any medication?
No, sir.
Are you clear-headed about what you're doing in court today?
Yes, sir.
Did you hear and understand the advisement regarding the meaning of a Fourth Amendment waiver?
Yes, sir.
Are you in agreement with that?
Yes, sir.
That will be a condition of your probation. All right, Mr. Bill, do you freely and voluntarily admit your guilt to the charges you face?
Yes, sir.
Do you admit the facts as alleged by the district attorney?
Yes, sir.
Do you now wish to enter your plea of guilty to the charges against you?
Yes, sir.
Mr. Bill, this morning you're represented by Mr. Raimondo, but were you previously represented by Mr. Jose Guzman?
Yes, sir.
Did you have enough time to discuss your case with Mr. Guzman?
Yes, sir.
Are you agreeable to Mr. Raimondo standing in for Mr. Guzman this morning?
Yes, sir.
And are you satisfied with their joint representation of you in this case?
Yes, sir.
Is there anything you'd like to say? You're not required to say anything. All right. Mr. Raimondo, is the recommendation that we heard from Ms. Flournoy the same that Mr. Guzman negotiated for Mr. Bill so far as you know and believe?
Yes, sir.
Have you had enough time, or you and Mr. Guzman jointly had enough time to prepare for this hearing today?
Yes, sir.
Do you believe that Mr. Bill understands his constitutional rights?
Yes, sir.
And do you believe that he has and he is making a knowing, intelligent, free, and voluntary decision to enter this guilty plea?
Yes, sir.
Other than to ask that the court follow the recommendation, is there anything further you'd like to say on his behalf?
No, sir.
Mr. Matthew Paul Bill, the court finds that you understand the nature of the crimes and the consequences of a guilty plea. The court finds that there is a factual basis to support your guilty plea. The court finds further that you understand your constitutional rights and that you have and you are making a knowing, intelligent, free, and voluntary decision to enter this guilty plea, which I will accept if you and your counsel will sign the charging instrument, but I actually have that in front of me and I see that it has been signed. So I will accept your guilty plea and I'll sentence you as follows. Count 1, possession of controlled substance, a felony, 3 years probation. Count 2, driving under the influence of drugs, less safe, misdemeanor, 12 months probation, served 10 days in the Muskogee County Jail, credit for time served, concurrent with count 1. Count 3, improper parking, a misdemeanor, 12 months probation, concurrent with count 1. Special conditions of probation, pay a fine of $750 in connection with count 2. Complete a DUI, alcohol or drug use risk reduction program within 120 days as required by the official code of Georgia annotated 40-6-391. If you have already completed such a program that is satisfactory to the Georgia Department of Community Supervision, you're relieved of taking an additional course. Probation Management Act sentencing option system with sanction caps of PDC or RSAT. Perform 80 hours of community service and your rights under the Fourth Amendment to the United States Constitution are waived. That is your sentence, Mr. Bill. Do you have any questions about your sentence?
No, sir.
Did you hear and understand the advisement regarding your rights to file a habeas corpus petition?
Yes, sir.
And did you hear and understand your rights regarding your right to file an appeal to this guilty plea?
Yes, sir.
All right. Good luck to you, Mr. Bill. When would the Department of Community Supervision like for Mr. Bill to report?
He can report within 24 hours to 1334 Second Avenue.
Okay, do you understand, Mr. Bill?
Yes, sir.
All right, thank you. Good luck to you.
Thank you.
Go ahead. Go ahead, Your Honor. Sorry to cut you off.
Well, I was just going to recall Marcus Hawk to see if Mr. Whitaker had arrived.
Okay. Mr. Bell, I'm going to give you a call real quick, okay?
All right, that concludes our guilty plea docket. Nikki Mims was not present. Is that correct?
And that is correct. She was present earlier this morning, Your Honor. She disconnected from the Zoom call. I have tried to call both numbers that I saw for her, and I was unable to get a response. If we could add that one to tomorrow's docket, and hopefully we can, Mr. Guzman and I will be able to get her back in here.
All right. Ms. Leonard, if you would take care of adding her to the docket tomorrow, please, I would appreciate it. All right. As I say, that concludes the guilty plea docket. Now let's go to our next docket, which will be the pleas and motions and status conference docket. Do I have those other two dockets? All right, we're the first well, Heather Jury is on the docket for a bond hearing. Mr. Jackson represents her. Has he joined us on the Zoom, Ms. Barker, or is
No,
he
Judge,
still at?
I'm sorry to interrupt. Yes, Your Honor, he's still in court in the trial with Judge Mullen. So it should be after lunch when we would have him available.
All right, we'll recall that this afternoon at 1:30 when we reconvene. Sandra Treadway. Mr. Johnson? No, he asked that that be removed. Okay, that was number 3. Number 4, Spencer Ryan, also represented by Mr. Jackson. This will be recalled at 1:30. Number 5, Javarius Gary, bond has been agreed to, as in his case in position number 6. Number 7, Anthony Keith Carr. It's a bond hearing. Mr. Ramondo.
I apologize. I keep on talking over you. I'm really sorry, Your Honor. Mr. Carr actually already bonded. He bonded very late yesterday, so that can be removed.
All right, thank you. This Zoom technology does allow us to work. I'm glad that it's available, but it's an imperfect way of conducting court, and it's easy to talk over someone. So I take no offense, Mr. Ramondo. Okay. Number 8, Kashwandra Irving will be passed as Mr. Kendrick is in trial with Judge McBride. It will be set down for the date in April that Ms. Leonard earlier mentioned. Is Kashwandra Irving on the Zoom call?
No, Your Honor, she's in the jail.
Okay. All right. On her case that appears in position 9 and 10 will likewise be passed to that date in April, as will her case in position 11. Number 12, Cordera Caravel Bellamy. Mr. Raimondo.
Your Honor, that was on a status. There's nothing to do on that today. We can just remove it from the docket.
All right, it's removed. Number 13, Jaquarian Flowers has been closed. Number 14, Neil Williams. Are you going to handle that, Mr. Raimondo, or should we call that at 1:30?
We can call that at 1:30, Your Honor. My understanding is that there was just an evaluation pending in that case that was signed this week. So I think there's some movement on that case.
All right, thank you. We'll recall it at 1:30. Number 15, Billy Wright will be passed to that April date, Ms. Leonard, as Mr. Kendrick is in trial. Number 16, Trevon McPherson. Mr. Deaver.
Yes, Your Honor. At this point, we're just waiting on an offer or a negotiated plea in this case. I didn't know who was handling it. I assume Ms. Flournoy is handling it now. Is that correct?
And that is correct. And I can.
Ms. Flournoy,
very
something
different
happened.
case.
Okay.
I don't know what's going on. I have to.
Okay. Well, if you have an offer, perhaps you and Mr. Deaver could talk during the lunch break. If you want me to put it down for 1:30, I will. Do you think that's enough time, Mr. Deaver and Ms. Flournoy, or do you want it passed until the April docket?
I would ask for it to be passed till April, Your Honor, just because there's the facts in this case. It's a very strange accumulation of facts in this case.
Is that agreeable, Ms. Flournoy?
That's fine, Your Honor.
All right, then it's off for today. Number
Thank you, Your
17. Yes, sir. Do you have other business, Mr. Deaver?
I do not, Your Honor. May I be excused?
Yes, sir. Have a good afternoon. Thank you. Number
Y'all too.
17.
Be safe.
Thank you. Appreciate it. Number 17, Onesha Phipps will be passed to that date in April. It was mentioned by Ms. Leonard because Mr. Kendrick is in trial. Number 18, we're back to Keshwandra Irving, another case also passed because Mr. Kendrick is in trial. Number 19, Amanda French, is passed to April the 7th due to Mr. Lake's leave of court. Number 20, Raymond Ikovic is passed to April 7th due to Mr. Kendrick's involvement in a jury trial. Number 21, Keshwandra Irving, again, is passed until that April date. No, because Mr. Kendrick is counsel in this case. Number 22, Keshwandra Irving, again, passed until April, I believe we said April 7th. Yes, that's correct, April 7th. And number 23, Leotis Shelton. Mr. Raimondo, are you going to handle that or should it be called at 1:30?
Your Honor, that was on for a status. I would talk to Mr. Guzman. There's nothing to do on it today. We can just remove it from the docket.
All right, very well. It is then removed from the docket, which brings us now to the VOP docket. Number 1, Craig Jones.
Your Honor, go ahead. Sorry.
Is Mr. Jones in jail or is he on the Zoom call?
Your Honor, the jail is muted. And I do believe that's Mr. Jones in the camera.
All right. Can someone unmute? It looks like the jail is now unmuted. Are you Craig
Yes, Your
Jones?
Honor.
Sir, are you Craig Jones?
I am, yes, sir.
All right. Who is Mr. Jones's counsel?
Actually, Your Honor, I came this morning to ask if I could have a little more time to secure counsel. At this point, I don't have anyone right now to represent me. I've been talking to lawyers. I need a little bit more time to make arrangements.
Just be candid with me, Mr. Jones. Do you think you're going to be able to pay and retain an attorney? Or do you wish to have this continued until the 7th of April and perhaps go see if you qualify for the services of the public defender?
If we can do it till the 7th, that would be fine. I would still prefer to try to hire an attorney if possible.
All right.
If I can't find one, then I'll try to go back to the public defender.
All right. All right. Well, that's what I will do is I will continue this until April the 7th.
Well, thank you, Your Honor.
Between now and then, either retain a private attorney or call the public defender's office and see if you qualify for their services. But you're free to leave this morning, Mr. Jones.
Okay. Thank you, sir.
Okay.
All right, great. Good to see you, man. I haven't seen you in a while.
All right. The next case is Lee Carter, represented by Mr. Stacy Jackson. We'll call that case at 1:30 this afternoon. And Sandra Treadwell has been rescheduled also. So that completes our dockets for this morning, except for the callbacks this afternoon. Is that correct, Ms. Flournoy?
That's correct, Your Honor.
All right, I see Ms. Barker nodding her head in the affirmative. So we will stand in recess until 1:30 this afternoon. Thank you.
1:30.
1:30. Yes, sir. And we stand in recess.
Jack, can I have your list?
Peggy, I'm going to leave the live stream running. I've got it, everybody muted. So there's just nothing going out on YouTube right now, except the pic.
All right. See you at 1:30.
Have a good lunch.
You too.
This is Deputy Burke of the jail. Can y'all hear me?
We've got you loud and clear, Deputy Burke.
Thank you.
That ain't good.
A lot of these cases, they pass. Oh. Yeah. Shoot. Lots of work. That's easy today done on Zoom. still only got like 5 kids.
We ain't got but 2.
Good.
That's all we got, 2.
That's it. I would like to see if they want to go ahead and get them out the way first. I would love to get them out the way. I'll let the judge know. That's what we do. Go and get y'all out the way. Then that way it'd be smooth sailing.
Probably have to check with Liz, since Liz.
I'm right here. I'm kind of listening a little bit.
Oh yeah, we just sent you there. We talked about Liz. Do you all want to go ahead and get Spencer and Jury out the way? They're in jail. If y'all want to get those out of the way and get them down, and then we get the next 3.
Ooh, sorry.
Yeah.
Spencer and Jury?
Yes.
Yeah, I'll make sure he knows on the jail list that I'll make sure he knows that.
We can get them out and get them cleared.
Hey, Lizzie.
I'm waiting on Mr. Jackson. There he is right there.
Hey, Lizzie.
Hi, honey. How are you?
You don't miss me, do you?
I do miss you. We'll be all together on Monday.
Oh, we will? You gonna
Yeah.
come down here?
No, y'all are coming up here to the 7th floor, 9 o'clock, Monday morning.
Why?
Trials, boo. Yes,
I'm-
sir.
No, I'm in the jail, baby.
Are we meeting at the Civic Center on Monday? Or are we coming there first? We're going
Here
straight to the
first.
Civic Center, right? There first?
First. 7th floor first.
Oh,
Peggy.
okay.
Directions.
Oh, okay. Where are those?
On the trial docket that got published.
Oh, I haven't printed that yet.
Here, 7th floor, 9 o'clock, Monday morning.
I wait to print that stuff because a lot of times I print it and then you update it and I have to I have to kill another tree.
Oh,
So
we
I
can-
wait till I'm sure you're updating it before I print it.
You can go ahead and print it.
Okay.
Okay. Huh? No, you do not. Excuse me, let me mute myself. Is everybody ready? And I'll let Judge know we're ready to go. Mr. Jackson, I see you've joined us. Mr. Guzman. Ms. Flournoy.
I'm here.
Hi, honey. Okay.
What's the first one you want, Liz?
Wait till he comes out. I don't know what he wants to do first.
Are you ready for him?
Yeah, go ahead. Let him go out.
Right. Good afternoon. We'll now go to our motions and status conference docket. Number one, Heather Jones. Is Mr. Jackson with us?
I'm here, Your Honor.
Okay. That's a motion to reinstate bond. Is that correct, Mr. Jackson?
That's correct, Your Honor.
All right, and we have Ms. Flournoy for the state. Are you both ready to proceed?
Yes, Your Honor.
All right, we'll need Heather Jury in the courtroom.
Please, Heather Jury. Coming forward, John.
Thank you.
Mr. Jury, just stand right there. With Judge, and I think you've been represented by Stacey Jackson.
Yes, sir.
It's gonna be good so here close. That
Okay.
the door don't swing and hit you in no way.
All right. Hi, good afternoon, Miss Jury.
Hello.
All right, Mr. Jackson, this is Miss Jury's motion. Whenever you're ready. Oh,
Judge Smith, I'm going to text Mr. Jackson and let him know he's got a connection problem.
all right. Thank you.
Can the court hear me?
It sounds like a banjo, Mr. Jackson.
Your Honor, if I could have one moment, I'm gonna try to log in on another device.
Okay.
Seems like I got a connection problem.
All right. Deputy Bourne, is this gentleman involved in a case or is he just observing?
He's involved, Judge. He said he's the victim. And that is his wife or soon to be ex-wife.
Your Honor, if his name is Mr. Hensley, that is the victim in this case. And he did not have Zoom capabilities, so he said he was going to come to the courtroom.
All right. All right. That's fine.
He asked Judge if he was able to speak. He would like to speak as a victim.
This isn't. he's involved in the first case with Mr. Jackson or in a probation case?
The case, Miss Heather, jury case, he's the victim in that particular case.
Okay.
It is my understanding he wants to speak on the issue of bond.
Right. He's going to need to go to the jail so he can go to the podium and speak. We don't have a way to put him on camera here. Do we?
How am I now, Your Honor? Can the court hear me?
It's better, Mr. Jackson, but we've got a gentleman here who is a victim in the case and wants to be heard. Doesn't he have a smartphone or something?
Your Honor, if you could send him over to the victim witness office, and I will make it. I will get him on a camera here. That way, he doesn't have to go all the way to Recorder's Court.
All right. Where is your office?
In the west wing on the first floor.
Okay. He's on his way over there. Let's go to the Spencer Ryan bond hearing. We'll come back to the jury, the Heather jury's case.
Ryan Spencer. Just stand right there. Yeah, stand right there. She's going the judge is going to call her back because the victim is trying to get on. She's having Zoom difficulties, the victim. So he said, just call up the next case. Yeah, go ahead and just cover. Can you use mine? I can use mine. Just stand right there. This is Ryan Spencer, Your Honor.
All right. Good afternoon, Mr. Ryan. Mr. Ryan. Mr. Jackson, this is your client's motion for bond or bond reduction. I'm muted. No, I'm not.
Okay.
Mr. Jackson, can you hear me?
Yes. Can you hear me, Your Honor?
I can. Ms. Flournoy, can you hear Mr. Jackson?
Yes, sir, I can.
All right. And your audio is much better this afternoon, Ms. Flournoy. I don't know.
Well, thank you. We worked on it over the break, Your Honor.
Well, thank you for that. All right. Mr. Jackson, are you ready to proceed?
Yes, sir, Your Honor. This is case number SU 2020 CR 2608. We got 2 counts of child molestation. Both bonds are $40,000 each. 2 counts of enticing a child for indecent purposes, $20,000 each. From my understanding, as to this date, the case has not been indicted. To my understanding, Mr. Ron has been incarcerated the entire time since his arrest. So we just asked the court to reduce the bond 50%. He is a resident of this county, Your Honor. We don't believe he poses a threat or danger or risk to person or community or property, and no risk of committing a felony while pending trial. From my understanding, he does not have any prior felonies. And most importantly, he poses no risk of intimidating witnesses or otherwise obstructing the administration of justice. So we're asking for that bond to be cut in half, Your Honor.
All right. And
each count.
What was his date of incarceration, Mr. Jackson? Or Ms. Flournoy? Or Ms. Leonard?
Raise your hand. Mm-hmm. Ryan. Go ahead, John. I'm sorry.
You had frozen up there for a moment, Mr. Jackson. I was asking him what was his date of incarceration.
Your Honor, I thought that I had that in my notes. That's why I was going to swear Mr. Ryan in. I know that I came in on the case August of 2020. August 19th is when I was hired. So it would be previous to August of 2020.
Okay.
And I apologize, Your Honor. I do not have the date. I do know from the information I have, he's been incarcerated approximately 227 days.
Okay.
But
Okay. All right, Mr. Jackson, whenever you're ready. Do you
So,
have any,
Your Honor,
do you have any testimony, or is it going to be argument strictly?
just argument only, Your Honor. I don't have any testimony as of right now. There may be something I put on the record, but I'll allow Ms. Flournoy to present her case first, and just depending on her, I may have to swear my client. But other than that, that's all, Your Honor.
All right, Ms. Flournoy.
Your Honor, we didn't have any testimony. I just had argument basically on the facts of the case and the bond. We are opposed to reduction of the bond, given the nature of the charges and the age of the victim. We feel like, and I'm going into my argument, so do you want me to wait or go forward?
No, Mr. Jackson has the burden, so he'll have the last argument. So I'm happy to hear from you now, unless Mr. Jackson wants two arguments.
No, go ahead, Ms. Flournoy.
Okay. Your Honor, this is a case involving a family friend, and the victim is 13 years old. This is not, there's allegations that there were 3 incidents. It was not a one-time incident. And also in this situation, the defendant was a family friend. So regardless of the situation, he was aware of the age of the victim. There's also been information, I believe, that possibly that he's some friends or family members of him has made an attempt to contact the victim. So we would say that some evidence or some argument that he may have some type of influence over, be able to intimidate or influence the witness. Your Honor, also given that he's had this relationship with the victim, we also want the court to know that he should, there is some influence that he's already exercised over the victim in terms of having this relationship with her. It is our position as a state that the bond is appropriately set at this time. It would oppose any reduction in bond.
Okay. Any idea when you might be able to present this to a grand jury? Ms. Flournoy?
Your Honor, at this time, I cannot say. I would say that I will be reviewing it as soon as possible. And I would say within the next month, if at all possible, I will work diligently to get it before the grand jury within the next 30 days.
Okay. All right. All right. Thank you, Mr. Jackson.
If I could just swear Mr. Ryan in very briefly, would you raise your hand, Mr. Ryan? Do you swear firm testimony you should give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I swear.
Just in response to 88 Flournoy's, specific response to 88 Flournoy's concern about risk of intimidation of a witness, have you received any correspondence by mail written to you by anyone from the victim or the victim's family?
Yes, sir.
Okay. Have you received any letters or documents from the victim in this case?
Yes, sir.
And approximately how many letters or documents have you received from the alleged victim?
2.
2. And
the 1st of February and the 11th of February.
Okay, that's all I have. And you, that's all I have. Questions, Your Honor. So I need to put that on the record.
All right. Well, that may be something that Ms. Flournoy wants to make inquiry regarding on cross.
That's fine, Your Honor.
Mr. Ryan, was there any prior contact with the victim prior to that?
No, ma'am.
Those letters?
No, ma'am.
And what was, you say you received correspondence. What was the nature of the correspondence?
They were letters addressed to me from the alleged victim.
And what was in the letters?
she had addressed me and said that she had messaged me, and she said that she is sorry for what she did to me, that no matter what they say about me, it's not true, and that I have the letters upstairs, ma'am.
Okay, okay. And there was, you saying that there were two letters from the February the 1st and February the 11th?
Yes, ma'am. And in the second letter, she had asked me to let her know somehow if I got the letter, so that way y'all know I haven't responded back to them.
Okay, and you received those letters at the jail?
Yes, ma'am.
Okay. Your Honor, I have no other questions at this time.
Anything else, Mr. Jackson?
Nothing more argument, Your Honor. Just
Okay.
made my final argument, that's all.
All right. Well, let me hear
If I
your
can.
argument. Yes, sir. Whenever you're ready.
Yes, Your Honor. I think as far as the factors for the court granting bond, and as far as that last factor, posing risk of intimidating witnesses or otherwise obstructing the administration of justice, well, in my opinion, the most important one. The victim has reached out to my client on several occasions. So I think that's proof in itself that there's no risk. And he's been in jail the entire time. Every phone call he makes is recorded, and there's no evidence that he's tried to contact her. It's actually the other way around. She's contacted him. So I don't believe there's any risk of intimidating witnesses or what have you. And obviously, we would agree to any type of conditions of bond with a reduction. It's already in the bond from that no contact with the victim or what have you. So obviously, even though the alleged victim is reaching out to him, we still have no problem with that issue and the other conditions that are listed on the September 9th bond order, Your Honor.
All right. All right. Well, so what I'm going to do today. Oh, well, first of all, Ms. Burdette, are the victims aware of this hearing today?
Yes, Your Honor, they are aware. They did not wish to participate, but they do have the YouTube link.
All right. All right. I'm going to make a very slight reduction in the bond, just in recognition that he's been in jail now for well over a year, well over half a year. I'm going to reduce the bonds across the board by 10%. So in the aggregate now, it's 120,000. So it will be reduced by $12,000.
Yes, sir, Your Honor.
If you would prepare the bond, Mr. Jackson, I'll sign it now. Let me say this: if a month or so passes and the case still has not been presented to a grand jury, I would entertain another motion for a bond reduction. All right.
Yes, sir.
For clarification, I'm sorry. For clarification, I just want to make sure that all the conditions about no contact with the victim and all of those conditions are still in place.
Well, that's a fair question, Ms. Flournoy. The only thing that's going to change is the amount of the bond. All the other conditions previously imposed will remain valid.
Thank you, Your Honor.
Yes, ma'am. Okay. Okay. I see the gentleman who came to the courtroom for the Heather jury hearing. So we'll go back to that.
And the jury is also coming forward, Your Honor.
Okay. Thank you.
They're through with him, sir.
All right. Good afternoon again, Miss Jury. Mr. Jackson, this is your client's motion to reinstate a bond. Would you like to make an opening and then call witnesses?
I'm sorry. Yes, Your Honor. This involves Heather Jury. Is the court indicate case number SU 2019 CR 2451. From my understanding, the bond was granted initially. I don't believe I was the attorney on the case at that time. $100,000 for fraudulent business practices, criminal receipt of info under false pretenses, and there's 3 counts rather. I'm sorry, Your Honor, and distribution of sexually explicit contact. Before she actually made bond, she was released, from my understanding, as a part of the pretrial release, Your Honor, since this was not a violent crime or not a violent felony as far as physical injury. So I think under the conditions of the pretrial release, that she was allowed to be released from jail without making bond. And then I'm not exactly sure because there was nothing actually filed with the court because since it was pretrial release, the sheriff's department make their own decision on if someone is violating the pretrial release. So I'm not exactly sure why that her pretrial release was terminated and she was placed back in jail. But from my understanding of the circumstances, the case has not been indicted, and it involves no allegations of any violent activities. It's basically in the sense of a computer crime. Your Honor, so we would ask.
Mr. Jackson, you're breaking up badly.
No, she go back uncomfortable with that. Now, can you hear me now, Your Honor?
I could hear you, but you were breaking up. Try again. I heard you say it was unindicted and there was no evidence of violence, and that's about all I got from what you said.
Yes, sir. So we're just asking for the bonds to be set at $5,000 each, or an alternative, go back on pretrial, judicial pretrial release. One or the other, Your Honor.
Okay, where did the $100,000 figure come in, Mr. Jackson?
Honestly, Your Honor, I have no idea. I have not ever seen a bond being set at $100,000 for what's determined to be a nonviolent computer crime. I believe there was an amount of money stolen or something to that effect. So I have no idea why that $100,000 bond was set in that way. That was done prior to me taking over the case, Your Honor. So I'm not sure if Superior Court judge set that or Recorder's Court.
Okay. All right. Can you shed any light on that, Ms. Flournoy?
Your Honor, I'm not aware. I don't have any indication as to why it was set for that particular amount. I'm not sure.
Well, I guess my question would be, was it set by me or another Superior Court judge, or is it the bond that was set in Recorder's Court when the case was bound over?
If the court may give me a moment while Ms. Flournoy responds, I'll look in the court portal system and see if I see an order, Your Honor.
Okay, thank you.
Your Honor, I believe it may have been set in Recorder's Court. Total amount was $175,000 with conditions of no contact with the victims and no internet use.
Okay. There are 5 offenses that's listed on the docket: fraudulent business practices using the internet, unauthorized request or disclosure of criminal history. Unauthorized request or disclosure of criminal history. Yet another unauthorized request or disclosure of criminal history. And then electronic transmission, post of video or photo. I think the word would have been depicting. I'm assuming that was some inappropriate or something deemed inappropriate to be transmitted. And I need to know what the charges are. I need to know a little bit about the facts and her connections with the community, whether she has prior felonies, so that I can make an evaluation about the possibility of future violations or the likelihood of future felonies. So if you can go back and fill some of that in, Mr. Jackson, it would be helpful to me.
Yes, sir. As far as she's a resident of lifelong resident of Columbus. She has her parents live here. She has significant ties to the community. She was actually, get into a little bit of facts, actually my understanding, working for the Columbus Police Department in one of their, not as an officer, but in another administrative capacity. And I think the allegations are that she may have run a GCIC check on someone without their permission. That's the only thing I know about those charges. And as far as Georgia Code 16-11-90, which I'm assuming is the basis for the distribution of sexually explicit content, I was not present at the record score hearing, so I'm not sure what exactly that charge is in reference to or what was alleged. But like I said, as far as the unauthorized disclosure for criminal history records, that's my understanding. But I do not have the recorder's court transcript to flesh out more information for the court. But I know she has no prior felonies, and I don't believe she's at risk of intimidating any witnesses or obstructing justice, Your Honor.
Thank you. Ms. Flournoy, the alleged victim has come down to the courthouse today and is now in Ms. Burdett's area, and he wishes to be heard. Do you have any other witnesses or just argument, Ms. Flournoy?
Just argument, Your Honor.
All right. Do you want to examine the victim or just let me have him make a statement?
Your Honor, whichever is your preference is fine with me. It's as long as he's heard.
All right. Tell me your name, sir.
Miles Hensley.
Miles Hensley?
Yes, sir.
Okay. If you would raise your right hand and take an oath to tell the truth. Do you solemnly swear or affirm that any testimony you may give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you. You can put your hand down. Just tell me what's on your mind that you want me to consider this afternoon in determining whether to set a bond or to reinstate a bond.
Yes, sir. I've recently learned that this is a bond hearing, and I come here to tell you two things. I don't oppose to her making bond, and also with times are hard right now. COVID-19 expenses. I was just going to ask you flat out if you can release our ROR on all charges. I'll keep it short, but if she makes bond, I'm pretty sure she'll abide all the conditions of bond, and there won't be no trouble from it. Also, she can be working and paying her living expenses and now her legal expenses. Hypothetically, I haven't talked to her, but I'm sure it's my opinion that it's just not really necessary for her to be incarcerated.
All right. How are you the victim of this crime, sir? Or are you the victim, or are you here to speak on her behalf?
I am labeled the victim, and I am here to speak on her behalf.
Okay, so you both, okay. All right.
I know when you're looking at the paperwork and you see these charges, they seem very extreme, but they're really not that bad. They say I'm the victim. Well, I can tell you I'll be just fine. There's no harm done. And like I said before, if you release her from jail, nothing bad will come of it.
Okay. All right, Mr. Jackson, I'll give you the first opportunity to cross-examine this gentleman.
Yes, sir. I'm sorry. Could you give me your name one more time? Sorry.
Miles Hensley.
Mr. Hensley, I'm going to ask a question about a lot of times when there's a computer crime, there may be a financial loss for the alleged victim. You haven't, based on your testimony, you haven't received or I guess your personal information used in a way so that you suffer some type of financial loss in any way, or lost employment, or any consequences as an allegation of these charges?
No, absolutely not.
Okay. All right.
This whole case is just a big waste of tax dollars. She and I had a little thing back and forth, and it escalated to this. Like, there was no harm done. I'm just fine. My credit's just fine. Like I said, again, it's just not really necessary for her to be incarcerated. There's a lot more people out there that could take her space in jail.
Were you finished with your examination, Mr. Jackson?
Yes, sir, Your Honor.
Ms. Flournoy, any
Thank you,
questions?
Your Honor. Mr. Hensley, what is your relationship to the defendant?
Ex-wife.
Okay, and it is alleged that she released GCIC criminal records. Were your records released? Were your criminal records released as a result of this, what she did?
Not really. I saw.
Okay.
Okay. Yeah, not really.
Okay, and so you don't believe it's a serious matter when someone releases somebody information that is protected by the law? You don't believe that's a serious matter?
I do believe that's a serious matter, and yeah.
Okay.
But like I said, there was no harm done, and truth be known, all the girls that work at 911 do it. The only difference is I told
You don't
them.
know that to be fact. That is your opinion, clearly.
That is my opinion.
And it's your opinion there is no harm done. Have you spoken with any of the people that any of the victims whose records were released? Have you spoken to any of those people?
Yes, ma'am. And they know I'm here today.
But they chose not to be here today.
They chose not to be here today, okay. and they're okay with me coming here and speaking like this. In fact, they could care less about all this. Really.
Okay, and that's again, that's hearsay, but I'll take it up in argument. Your Honor, I have no other questions of this witness.
Okay, anything else you want to tell me, Mr. Hensley?
Like I said, I know ROR is a lot to ask, but there's no way she'll ever have a fair chance at making that kind of bond. It's just too high.
Okay.
And she has a lot of roots here. She's, like I said, if she's released from jail, nothing bad will come of it.
Okay. All right. All right, Mr. Jackson, you have opening and closing argument. Would you like to make both or just reserve your closing?
Reserve closing, Your Honor.
All right, then Ms. Flournoy, you have the floor.
Your Honor, I just want the court to know that the state is not opposed to a reasonable bond. However, we are opposed to an own recognizance or unsecured judicial release of the defendant under these circumstances. While Mr. Hensley is one of the victims and he doesn't think it's a serious matter, Your Honor, the defendant at the time was employed with the Sheriff Department with the 911 center, and you have an obligation you take an oath that you're going to, or sign an affidavit that you're not going to use the Georgia Crime Information Center except for official use. She took advantage she was put in a position of trust and took advantage of that position to get information on people that she did not have the authority to. That is a serious matter, Your Honor. And we are asking for a reasonable bond, but most certainly want to court, not to dismiss it as something, even though it's not a violent crime, it is a serious crime because she violated her duties as a 911 employee. And then not only did she violate it, she further released the information to Mr. Hensley. And then it's also alleged that she posted pictures of Mr. Hensley genitals on Facebook. So this is a serious situation, Your Honor. We would ask that the court, we're not opposed to bond, and in this situation, a reasonable bond, we would just ask the court to give a reasonable bond, but not a own recognizance or a unsecured judicial relief. We feel that would be appropriate in this case.
All right. Does the state have a bond amount in mind that you would suggest?
Your Honor, I would suggest that basically on the fraudulent business practice to reduce that to probably about 50,000, and then the remaining charge you can do about 10,000. That would be my suggestion. But certainly, if the court decides otherwise, we are okay with that.
All right, Mr. Jackson, your argument, and I'd solicit a suggested bond amount from you as well.
Your Honor, I just think that even a $50,000 bond on that charge and 10,000 is pretty draconian. I understand that there's maybe other victims, but it sounds like he's being Mr. Hensley. He's the one who had for lack of a better term, penis pic floating out there. And if he is stating that he's not opposed and that he does not feel he's been victimized, and then also too, the other alleged victims in the case, I think by them not wanting to be present for the bond issue shows that a level of non-concern, because even if they didn't have Zoom capabilities, I'm sure Ms. Burdette would have taken any type of statement from them by email or by phone call to express, their witnesses. I'm sorry, not witnesses rather, but express their concern. So based upon their lack of interest in the case, and also Mr. Hensley's interest in that seeing this jury be released, I would ask the court again for the judicial unsecured judicial release, or at the minimum $5,000 for each charge. That's still 25,000 reasons why a bonding company would make sure that she's in court. But she has an attorney now. She's done everything she's supposed to do, and that we don't expect her to cause any problems if she's released out on bond, Your Honor.
And Your Honor, I do want to verify that based on the information I have, she does not have any prior felony convictions.
All right. Well, the charges are serious, but Ms. Jury has not been indicted, and she is cloaked with the presumption of innocence. The purpose of bond is not punishment. Pardon me, just a second. I'm going to set the bond on the fraudulent business practices at $10,000 and then $5,000 on the other other 4 counts. She is not to have access to computer, the internet, smartphone, or adult-oriented materials. She is not to contact, well, Mr. Hensley, do you and the defendant have children together?
Yes, sir. We don't have anything financial or children. We don't have
Okay.
anything, Ted.
All right. Well, there should be no contact with or attempt to influence any of the victims in the case. Do not violate any federal, state, or local laws or ordinances. Are there other conditions that you have in mind, Ms. Flournoy?
Your Honor, those were the conditions that I had in mind. So thank you, Your Honor.
All right. All right, Mr. Jackson, if you'll prepare the bond order, I'll sign it as soon as it arrives. Okay, thank you.
Yes, thank you, Your Honor. And may I, I'm looking over my docket, and I believe that's all I have with the court. May I be excused, Your Honor?
Yeah, yes, sir, that seems fair. You have a good afternoon, sir.
And yes, sir, Your Honor, I think, thank you too, I forgot to mention this, for accommodating my schedule since I'm bouncing back and forth between that murder trial and Judge Mullins. I appreciate the court accommodating my schedule.
Judge Smith, may I interrupt? Mr. Jackson, do you have the VOP number 2, Lee Carter, before you release?
We got it. I don't believe so. I've had my staff. I'm not sure. Am I listed as the attorney of record on that case?
We thought you were, but I'll.
Ms. Leonard, can you shed any light on that?
Judge, I'm checking on it.
Okay. Well, Mr. Jackson, I'm happy to accommodate you. You're kind of stretching yourself thin.
Yes, sir.
In a serious criminal jury trial in the morning and then doing hearings in the afternoon.
No, it's not Mr. Jackson. It's actually Mr. Kendrick.
Okay. Mr. Kendrick is in trial, so we'll have to move Lee Carter maybe to that April 7th date that's been mentioned.
Yes, sir.
Thank you. All right, Mr. Jackson, with that, have a good afternoon and take care.
You too. Take care, Your Honor.
Thank you. All right, the last case we have on the docket is Neil Williams. And Mr. Guzman, I think you're with us this afternoon. Is that right?
That's correct, Your Honor.
All right, very well. Let's have Neil Williams come to the courtroom.
Neil Williams. I'm gonna go ahead and make a call, y'all.
Thank you. It's my time. All messed up again.
Court call for Neil Williams. Neil Williams. I think that's right. Thank you, Master. There's no, Mr. Williams is not in the courtroom. We made a call out in the lobby. There is no response, Your Honor.
Mr. Guzman, what's the nature of the, let's see if I can find it, answer my own question here. This is a status conference. Is there some matter that has that needs to be heard this afternoon?
No, Your Honor. on Mr. Williams, I'd spoken to Ms. Flournoy about an evaluation. We got an evaluation order for the court, and the court signed it this past Monday. And so that's done. Just regarding his, he knew to be here, Judge, but when I spoke to him, he's very hostile. That was, excuse me, that was part of the reason for the evaluation request. And so it wasn't just hostility. There were some other issues anyway, he did know to be here, but he just was arguing with me, and it took me quite a bit of time just to even get a little bit of information from him. And so that was part of the reason for the evaluation order.
All right. And the evaluation order, you said I've already signed. So
yes, Judge.
It's really nothing to be taken up this afternoon.
That's correct. Yes.
Do you agree, Ms. Flournoy?
Yes, Your Honor. And I don't see a need for a bench warrant either because the issue has already been resolved.
All right, very well. Well, that brings us to the conclusion of our docket this afternoon. Unless I've overlooked something, is there anyone on the Zoom who still expects to be heard this afternoon? Not hearing anyone. All right, then we stand adjourned. Everyone have a good and safe afternoon and stay well.
Thank you, Your Honor.
We'll see some of you tomorrow.